insincere apology is the worst thing that can ever be given. You know, I'm really sorry that happened to you because that put you in a position to sue me. That's not saying I regret what I did. It's not a sincere apology. A sincere apology is, I'm sorry this happened. I regret this happened. This should not have happened. Lee Taft would say that it's repentance. A sincere apology is the equivalent of repentance. To know that someone is genuinely sorry for what happened, not just sorry because it's created a problem for them too. And believe me, I've heard plenty of those types of apologies in litigation. In another life, I was a high school teacher. And quite often, if I would have something happen in the classroom that shouldn't have happened, I would ask the offender, what do you think you should have to do to make amends for this? And quite often, they would be much harder on themselves than I ever would have been when they would stop to think about what they'd done, if they'd taken something from another student or whatever it was. And so I think that allowing the offender to have a say in what they think their punishment should be or the restitution should be, I think would have a very good effect on that person. And anytime a person is involved in making a decision about something that should happen, they're very much committed to it. If they make a suggestion, they agree to it, the other people, they all agree, they've had input into that, and there's a commitment there to follow through. So I think that in terms of restorative justice, if that's the way it works, I think it would be excellent if they looked at the collaborative process and allowed on some levels, these people to do this. To get started in the collaborative process, of course, the first thing to do is to get trained. And I've done training around the United States, in Australia, different places, and I've trained people that have been to other trainings, and you know, they're telling me that a lot of us are doing things very differently, and a lot of times they'll ask me, is this right or is that right? And I'll say, you have to decide what's right for you. There's some things that are definitely wrong, but there's a lot of approaches to the collaborative process, and it's just different approaches. So the first thing is you need to get trained. You need to get in contact with other collaborative lawyers so that you've got communication going on and getting ideas, sharing ideas. And these people may be in your community. It may be a connection through, for instance, the Global Collaborative Law Council or the International Academy of Collaborative Professionals, the ICP, or maybe a practice group in your community. But get in contact with other people. And one-on-one is the best way to spread the word about the process. And so everybody you see, I think Larry said that I'm always asking people, who did you talk to about collaborative law today? And I do. I even had people call me or show up at my office saying, guess who I talked to about collaborative law today? And that's good, because we need to talk about it. One-on-one is the best advertising that you can do. You need to find people that work in your area. For instance, if you do probate work, you can get ideas. In San Francisco, there's a group called Redwood Empire Collaborative Group, and they're doing a lot in probate up there. In Boston, Michael Zatunian and Paul Faxton are doing a lot of work in business disputes. In Sydney, Australia, Robert Lopich is doing civil and commercial disputes. These people, all of these people are connected through these organizations that I've mentioned, and so they can contact each other, they can ask for ideas. I get emails from everywhere in the world asking questions about, what would you do in this situation, or who do you know that I can contact? So get on a listserv for a collaborative group, join an organization, learn as much as you can, and then go to somebody in your community that you respect as a professional. Have coffee with them, tell them about the collaborative process, and get you some folks you can dance with. Because that's the way you're going to have to get it started. If you get enough people, have some people come in and do a training for you if there's no trainings nearby. But as the word gets out about this, more and more people are going to get the idea, hey, I better find out what this is about. Not all of those people will be suited for the collaborative process. One fellow that I trained came back later, and he said, you said that we weren't supposed to do any surveillance of the other party during the collaborative process. And I said, that's right. And he says, well, I've got it all figured out. I'll just do the surveillance before we sign the participation agreement, and then it'll be all right. And I said, you know what you sound like to me? And he says, what's that? And I guess he thought he was going to get a compliment. And I said, you sound like a smiling litigator. And I don't think he was too pleased at that comment. But this fellow, he's not looking to participate honestly and in good faith. He is doing what the litigator does, and that's trying to get around things, get through things, to manipulate things, to make them go his way. Sometimes people talk about discovery, and they talk about this is what I need to support my position. This is the information I'm going to give them. It supports my position. When you're talking about positions, you're talking about positional bargaining. You're not talking about interest-based negotiation. So we've got a long way to shift over from this idea of mine, me, what I want, my position, to what's going to work for everybody in this dispute. What are your concerns? What are your interests? This is what is going to be the hardest thing for us to do, is to find a group of people that can make this shift. Hopefully, the law schools are going to start teaching collaborative law. Many are already teaching interest-based negotiation. And so students will begin to think in an entirely different manner than they did before. Larry Maxwell and I go out to Southern Methodist University every semester and speak to an ADR class there. And one of the times we went, this young man in the back of the room raises his hand and he says, "You're telling me I have to forget everything I've learned for the last 3 years?" And basically, I guess that's what we told him, because they were teaching him to be a warrior, and that's not what we need, or at least not that kind of warrior in the collaborative process. There's a lot of confusion there that litigation creates in people's minds. I guess I never was truly a litigator in the first place, because I didn't have as much to get over as some people did. I never quite learned to accept all that. But that's what we've got to do. So if you're wanting to start your practice, you need to go out and find people that, even if they think that way, they can understand what you're talking about. And it's amazing, because some of them will immediately understand and they'll get very excited about it. And others you can send to trainings for the rest of their lives, and they will never get the concept of interest-based negotiation and considering what you have to do to satisfy more than just your client. So I think that basically, to get started, that's kind of what you're going to have to do.